Thank you very much, Antoine, for that kind introduction. And it's absolutely an honor to be here and to be in the presence of such eminent authorities in this field as well. I am already looking forward or dreading the commentary that I'll be receiving. So the reason I got interested in the specific issue of climate change litigation, which, as you said, is not up my usual alley as I'm a general EU lawyer, is 3 years ago when the Hoge Raad, the Dutch Supreme Court, rendered the, I think, very well known to all of you ruling in Urgenda, where for the first time, to my knowledge, in the world, a court held that a government was obliged, on the basis of human rights, in particular the right to life, family life, and health, to take effective action to reduce CO2 emissions. And even did the court then specify a target in that regard, namely reduction by 25% as compared to 1990 levels by 2020. I thought that was an amazing, interesting, groundbreaking development. I avow a personal sort of green political orientation, let's say. But for me, what immediately sort of stood out as a question as an EU lawyer was, what could the European Court of Justice potentially do? Could it do something similar? And then at EU level, imagine how powerful that would be if you wouldn't just oblige the Dutch state to take certain actions, but you could oblige the EU as a whole. So I was interested in that question then, what could, but also of course should, the European Court of Justice do? And that question of should then provides a link to my other sort of recent research interest, which is about the legitimate role of the judiciary in a constitutional democracy that applied to the European Union as a transnational constitutional democracy in the making, and the Court of Justice's position in that. So indeed, that's what this paper tries to do. It's still very much a work in progress. That means that what I'm presenting to you is still raw research, of which you are the victims, because it means that, you know, some of this is quite open-ended and still up in the air. But I am, of course, benefiting from this greatly, because it means that I can take on board all of your critical comments and ideas still in the further development of this project. So please don't hold back after. How much time do I have, actually, Antoine?
30 minutes?
30 minutes, okay, good. Yeah, I guess that should fit. And cut me off if I go on too long. Okay, good. All right. So what I hope that we can get through in these 30 or 35 minutes is first then perhaps the most, what I find the most difficult part myself, which is to try and make explicit an analytical normative framework of what should be the role of the court on such political issues in a constitutional democracy. So from a perspective of democracy and human rights, constitutionalism. And also there in that first part, that theoretical framework, I already want to flag and potentially deal with a couple of feedbacks that I've already gotten when I presented this paper in the summer as to whether this framework is perhaps too human-centric, and what should we do with that, or what should I do with that, or is there not an alternative way then through human rights to deal with this, rather to say, well, the environment is in the end, when it comes to climate change, a pre-political question. We don't even have to worry in a way about normal parameters of democracy and constitutionalism, because if the world ends, we won't have any constitutions and democracies left anyway, right? So that's basically an alternative approach. So I want to put that to you, whether or not I need to accommodate that in the framework. And then I'll just spell out briefly what the Hoge Raad did in Urgenda and what has then happened since in international climate change litigation, on which we have specialists here in the room who undoubtedly have even more and richer knowledge of. And then applying it finally to what in the end is my main sort of interest and expertise, the Court of Justice and its case law. And there, of course, I will address the fact that the Court of Justice in Carvalho and others already dismissed a similar Urgenda type case, the People's Climate Change case, sorry, for lack of standing, lack of locus standi. So what should we do with that? Okay, so that's on the menu. The theoretical framework. So it was already in the title, right? Judicial activism. So I'm trying to think a little bit more critically about these terms, activism and deference, as they are often just thrown out. And give a little bit more meaning to it, because of course it's these terms that already go to the core of what we want to know. What is the appropriate role of the judiciary in relation to majoritarian decision making / democratic decision making? But therein lies the rub. I'm trying to make a difference between democracy and majoritarian decision making in the framework. So in, I think, sort of general understanding, maybe even the way this would be used beyond the legal community, a deferential court, I think, is understood usually as a court that tries to interpret the law as closely to the text as possible, and in case of doubt, maybe refers to the drafter's intentions, what did they want with this provision, and then align the interpretation to that. Whereas an activist court is a court that creates a bit more space for itself through creative interpretations that potentially depart from the strict text of the provision in question, maybe looking more at its meaning or the context, and using, therefore, also more creative interpretation methods. I think that the normative load behind these terms is that the first, the deferential court, is, among many accounts, I think, a more legitimate court, a court that understands its own limited place in a democracy, whereas an activist court is more difficult to justify from a legitimacy point of view, even though in the European Union, we are very used to thinking of the European Court of Justice as a very active court, although we don't always say that it is maybe activist. And there, I think we could usefully perhaps work with that distinction that I'm hinting at between active and activism. So maybe beyond deferential and activist courts, we can also think about active courts and inactive courts as kind of to enrich the framework. So this is my proposal to you. What do you think about this? An active court is a court that takes on itself an active role to constitutionally protect and enforce democracy. So it's not a court that says, you know what, I don't take democracy seriously, or whatever democracy says, I'm a constitutional body that derives its own independence separately from the democratic process, but rather a court that says, no, it is my duty, my constitutional duty, to actually protect and enforce democracy. And that's how I will interpret certain fundamental rights, for instance, as correcting certain failures in majoritarian decision-making that do not actually lead to a well-functioning, robust democracy in the long run without such judicial intervention, like For instance, but I think one of the most famous examples in this, minorities who are not, if they are structurally underrepresented in a majoritarian decision-making process, if they are not protected by the judiciary, this could lead to potentially grave injustices, right? And then we can no longer speak of a well-functioning democracy with a capital D. Okay, and then the opposite of that, so that notion of an active court, I think, also already exists in the literature. But maybe what I would most like to add is the concept of an inactive court. A court that is deferential. It is being sort of self-restraining, saying, no, this is a question for the political process, making it look very, responsible. But actually, it's abdicating its responsibility by doing that, because it should, in that case, if it was a serious constitutional court, have taken a more active role, right? So, having said that, I think what here is basically what I'm already repeating. So I'm going to skip. Yeah. So in my view, as I already hinted at, a true constitutional court has a mandate, even an obligation, to actively protect, make possible, a condition, if you like, but I think that's a loaded term, the democratic process, or let's say the majoritarian decision-making process, because that process, left to its own devices, will almost inevitably produce certain democratic deficits or democratic failures. I don't know how many of you are aware of law and economics and the concept of market failures. I thought that was quite a useful analogy. So the idea in law and economics is that the market generally is the best way to produce efficient outcomes, but the market suffers from a couple of failures that, if you don't intervene in the market, will actually not lead to the most efficient allocation of resources, such as information failures and so on. And I think you could apply the same thing to majoritarian decision making. That in principle, it is the best way to make decisions, but if you leave it to its own devices, it will actually collapse on itself. It will not produce the very outcomes it's supposed to produce because of some inherent failures. I should clarify, when I talk about democracy, what I mean is basically the democratic principle understood as ensuring that those that are significantly affected by decisions also take part in making those decisions. So, and why? Actually, why should that be? Well, I think ultimately you should make the argument that this is about dignity. So the only way to do justice to human dignity, then, in that framework, is to allow people to have at least some influence over the man-made decisions that affect their lives. Otherwise, if you rob them of that agency, then you are infringing their dignity. So, in a way, you can, I think, make the case for democracy as rooted in dignity, right? Okay. So then if we understand democracy and the democratic principle like that and what it requires, then just raw majoritarianism, rule of the majority, will fail to deliver that. It will fail to make sure that those who are affected by decisions can meaningfully take part in taking those decisions, because of what we already said. There may be persistent minorities that constantly are left out, because decisions can have external effects. So I may be affected by, in the Netherlands, by your decision here in Belgium, but I'm not represented in your decision-making process, right? So that's a failure of majoritarianism, nation-based majoritarianism. And of course, that's one of the major explanations always of why there should be transnational environmental law, right? Because of these externalities. The entrenchment of socio-economic inequalities, you know, the rich and the powerful, they will always be more savvy in and weighty in the majoritarian decision-making process, and then they might take decisions that entrench those advantages that they have, right? If there's no counterbalance or equalization mechanisms, information failures, and of course, short-termism. So the tendency for the way that we organize democracy is that, you know, we then count on these people elected for a couple of years who want to be re-elected and have immediate gains in the electorate to think about the interests of future generations or things that might manifest themselves only 50 years down the line. So that doesn't actually help us if we stick to that narrow operationalization of democracy in terms of parliamentary majoritarianism. Okay. So here we come, the lawyers. Huh? We are going to save the day. We're going to save democracy from itself then, right? Yeah, but we don't have carte blanche. So it's not just because there is a real case for an active judiciary in all this that it means that that active judiciary should then just be able to do whatever it thinks is necessary. I would say it allows a constitutional court to carefully act outside the textual limits of the law where this is absolutely necessary to prevent grave democracy failures in a democratic process. Okay, I've already hinted at the environmental implications of this. So there are various democratic reasons to reiterate for the transnational constitutional protection by the judiciary of the environment, rooted in the human right to health, to family life, precisely in light of the many democracy failures that decision-making on the environment presents. So this is a long-term issue. It is an interest of future generations that is not well represented. You can argue that there are enormous power asymmetries with established economic actors who have an active interest in also information manipulation in order to pollute the quality of democratic debate in relation to these issues. We can think about that, but I think it's actually quite intuitive when you think about climate change and environmental questions in this way, what the democracy failures are. Okay, so I'm gonna go a little bit further. I just wanted to, in this theoretical framework, highlight two problems or solutions. So the first is, why even bother with questions of democratic legitimacy and building all this whole framework of, you know, what is the legitimate role of a court in relation to majoritarianism, blah, 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 if you just see this as an existential threat. And if it's an existential threat, it's a pre-political question, like national security also is sometimes pitched to be, right? So we don't have to actually maybe apply the same standards of, you know, constitutionalism or even human rights, as we saw in the war on terror, for instance, because this is an existential threat. If we have no state, if we have no humans, it all doesn't matter anyway. So that would then legitimize wide-ranging emergency powers for the executive, right? Or in this case, maybe wide and discretionary powers for the judiciary. The Green Court's going to save us all. Yeah, I think I can't. I mean, I'm somehow appealed by the argument, but I don't think it stands up. I mean, I have to embed the exercise of authority in a constitutional framework, constitutional democratic framework. Otherwise, it can at best be, you know, what Rawls called benevolent dictatorship or something. But it can't be truly legitimate from my point of view. It otherwise means you adopt a framework of complete output legitimacy, where you say, okay, the outcome here justifies any means of achieving it. And I think that's incredibly dangerous and irreconcilable with constitutionalism. So then, okay, if you then say, okay, but then maybe I'm not a constitutionalist, fine, but I am. So then that's where my limit is. The other concern I am grappling with a little bit more. So one of the comments I got in Florence was, you know, all of this is too human-centric. Why are we rooting this case for environmental protection in human rights? This is not about humans. This is about the environment. It's an intrinsic value. And it's beyond it not being the sort of morally the right thing to do. It might also lead to certain biases then in the way we deal with this, because we only deal with this from the perspective of the human interest. Yeah, I still find that a difficult comment. So, yeah, what if we then, was the argument perhaps that followed on from that, if we instead give rights to not to humans to a healthy environment, but rights to the environment or to animals, right? So human rights for animals, basically. Which on the one hand, as some scholars have argued, challenges the very notion of constitutionalism, which is centered, as I already also alluded to, on the pillars of dignity and democracy. For me, even democracy rooted in dignity. On the other hand, the Swiss, in their constitution, as far as I understand, are understanding dignity not just as human dignity, but as dignity of all living beings. So, but this is for us to think about, maybe to discuss after the presentation and further down the line. Maybe the whole framework could still work perfectly well, and you just expand dignity as dignity of all living beings, not just humans. The whole reasoning potentially could still stand, and so a judiciary should be upholding at least the core of sentient beings' dignity. A dignity of the environment and of nature I find harder to accept, but of all living beings, I think you could potentially root it in the same ultimate sort of singularity of legitimacy that dignity is. Anyway, something to think about. Just noting that in the treaty, Article 13 already of the TFEU mentions, and that's a constitution, right? So to say, there is already a constitutional mention at EU level of the welfare of animals as sentient beings. And this already has played a role in the case law of the court on ritual slaughter and so on. So that means we already have a little bit of a hook for this in the EU constitutional framework. I find it theoretically perhaps a more difficult question if there are no such hooks in a constitution, whether a judiciary should then sort of impose that. So should a judiciary in a constitution that only references human dignity impose in that also a dimension of animal dignity? I'm undecided. I'm looking forward to your views on that. Anyway, so Urgenda. 3 years ago, the Hoge Raad, confirming some earlier rulings from lower courts, but unexpectedly, the whole literature was saying that this would not happen, but the Hoge Raad did confirm those earlier rulings, saying the Dutch state is obliged, on the basis of fundamental rights of human rights, to reduce the emission of greenhouse gases. The Hoge Raad engages a lot with the case law of the European Court of Human Rights in Strasbourg, but that court has not to date yet confirmed explicitly that states are under such an obligation under these rights as regards climate change, environmental disasters, and so on. Yes, so the Hoge Raad extrapolated from the case law that was already there, but it hadn't yet said this explicitly as regards climate change yet. But the Hoge Raad said, well, yes, it just applies also to climate change. There's a collective action problem here, and every member state should do it. Every country, sorry, should do its part. Because this is, of course, often an argument. So like, yeah, but what is the causality here? If the Netherlands doesn't cut CO2 emissions, or it does, what difference is it going to make in, you know, in the overall outcome? But actually, the Hoge Raad made short shrift with that and said, well, if everybody reasons like that, then nothing's going to happen. If everybody reasons the opposite, then we have a solution. So let's reason the way that we can have a solution. It was quite pragmatic. Of course, then there is the hot potato about the political question. So the Hoge Raad says, well, in principle, yes, this is for the political level to decide at international and national level. But that doesn't mean that the Netherlands cannot have an independent obligation, regardless of whether or not it has entered into international agreements, to do its part, and the judge has to supervise the government, its own government, to see whether that is the case. And it says, well, you know, there is overwhelming scientific agreement as to what levels of cutback are absolutely necessary. The Dutch state had said, yeah, but I am complying with all my then applicable EU law obligations, all the legally binding obligations I'm complying with. And the Hoge Raad says, yeah, well, but those standards are too low. And the EU has already itself admitted that politically. The fact that it has failed to make those standards binding doesn't absolve the Netherlands from its obligation to then do what is necessary. So, fantastic development from the perspective, of course, of climate change litigation, and I think about 100. I don't have the exact tally of cases that have then, since that judgment, been filed around the world, with some following in the footsteps of the Hoge Raad, let's say, the Irish Supreme Court, the German Constitutional Court. Although there is a bit of a hesitation to go as far as the Hoge Raad did in saying specifically, this means that by this year you have to cut this percentage of emissions as compared to then, but rather to say you're not doing enough. And why is that? Well, precisely what we are discussing, that the courts are feeling, well, you know, this is a task for the politicians so we can say you're not doing enough, but it would be too activist of us to say what you should then do.
That's what the Brussels Court of Westminster
yes, exactly. So that's, of course, a question of precisely what we are debating. I would like to also provide as food for the discussion the question how much it matters. To me, it does matter, at least to some degree, but how much it matters that there is overwhelming scientific consensus on a lot of these points. So does that then reduce let's say, the discretion of the political level and enhance the scope for the judiciary to be more specific? I do think it does, although there is a tension there as well, because at the same time, I'm quite critical of the idea that there are, on the basis of sound science, you know, always perfect answers to be found. And ultimately, everything is weighing of different truths, and that's political. So I'm myself a little bit actually entangled in not knowing where I stand on that point. And there are 5 cases, or now maybe even 6. I saw a new one was, but anyway, maybe our specialists know more, pending at the European Court of Human Rights in Strasbourg on this issue of climate change and human rights. Okay, I have like 5 minutes
No
left.
problem. Yeah,
Okay,
sure.
good. So coming then to the Court of Justice, I hope I've made a reasonable case why our court at EU level could and should potentially render an Urgenda ruling obliging the European Union to cut back emissions. But the problem is that the court adopts very strict rules as to who has standing to challenge rules, legislative acts of general application at the court. So how do you get your case to Luxembourg, basically? Because according to its Plowman doctrine, you have to be individually and directly concerned. Now, I mean, in theory, those words, being individually and directly concerned, don't seem to be that big of a hurdle. I mean, I feel quite individually and directly concerned by the existential threat in my existence. But according to the Court of Justice, this means that you should be concerned in a way that distinguishes you from everybody else here. So, are we all gonna die when this whole thing goes down? Yes, well then we're not individually concerned, right? Being a little polemic, but the thresholds of establishing individual concern and direct concern are extremely high. And in Stichting Greenpeace in the 90s, the court already said, in response to the argument that this is unjust, especially as regards environmental cases, that it wasn't convinced that the environment was different in this regard. Because of course, the environment being such a diffuse interest that affects all of us in a different way than maybe some other concerns do. Even the Advocate General in that case said that there should be standing, but the court was unconvinced. Arguably, because it doesn't want to work too hard. It's afraid there will be too many cases. The Aarhus Committee, so there is a convention, the Aarhus Convention on Access to Justice, has already set in a committee that assesses compliance with that convention and already said that this case law is not compliant with the Aarhus Convention, of which the European Union is a signatory. But anyway, the court has not been much impressed, has not changed its case law. And so when basically the Urgenda moment came for our Luxembourg judges, it was maybe no surprise that it just repeated its previous approach on locus standi and said, I can't deal with this case. So the complainants were arguing that the existing EU legislative framework was insufficient, very similar arguments as the Urgenda applicants had made. And they were families active in the agriculture and tourism industry. And they said that's why we are even sort of more than you and me here in this room. We are uniquely concerned by this because our livelihoods depend on not having the negative effects of climate change. But the General Court was unimpressed, not individually concerned. They were, and the Court of Justice confirmed that. Okay. So this is basically a repeat of what I said before, just applying the framework. So I think there is a huge problem here that the court sticks to this very strict and very high threshold of establishing standing so that you can bring a case to it, challenging basically the adequacy of EU action in relation to its human rights obligations in relation to climate change. There are plenty, obviously, of justifications based on democracy failures, as we mentioned before, in play here. And precisely the European level provides additional opportunity and responsibility, I think, compared to national-based climate change responsibilities, because this is a collective action problem. And if the Court of Justice would, like I said in the very beginning, if the Court of Justice would render an Urgenda, the impact of that would be enormous, right? So with power, and it comes great responsibility, and I feel that the court is not taking that responsibility. And as I said as well, the terms individual and direct concern are, I think, open enough to allow a reading that accommodates, you know, the concern of individuals when human rights are at stake. So that then means I'm not even asking the courts to disapply the strict letter of the law, we're actually asking just to give a reasonable interpretation of the law. So the fact that it doesn't do that, for me, really makes it illegitimately inactive in relation to climate change. So what the Court of Justice tends to say in response is there's always an alternative remedy. You can bring a case in your national courts, and your national court can then ask a preliminary reference to us in Luxembourg. And so there is no problem. But precisely the Urgenda scenario already shows that that is not true. It's insufficient. Why? Because the EU rules in question that the Hoge Raad was faced with, right, were minimum harmonization rules. EU member states are always allowed to go above. So the construction then for a national court to say that it is these minimum rules themselves that infringe somehow human rights, it's a difficult argument to make because member states can always go above, right? So the legal construction for a valid preliminary reference doesn't make sense, as far as I can see, because it's not relevant for the national court to give an answer to the question. The answer to the question of the state's responsibility is the state's own measures. It would only be different if the EU norm set a maximum, and then the national court would be prompted to ask the EU level, okay, but is this maximum compatible with human rights? Because I can't condemn my government for strict sticking to your EU rule. Okay. Now, there are some really positive recent developments. You see this beautiful rainbow. The legislative level has acted in the meantime. So we have now, since last year, an EU climate law and a revision of the Aarhus regulation. So the Aarhus regulation implementing the convention in the EU legal order has broadened the eligibility criteria for requesting an internal review of EU norms, allowing NGOs, environmental NGOs, and even individuals in certain circumstances to challenge EU acts on the basis of them infringing environmental law. On top of that, we have the climate law, which now lays down a legally binding obligation for the EU of climate neutrality by 2050. And as an immediate binding target, a domestic reduction of emissions of 55% compared to 1990 levels by 2030. So quite ambitious and, you know, more or less in a way in line with what some of the applicants in these litigation cases were actually arguing for. So then why am I still doing this presentation? So am I not mustard after the meal, as we say in Dutch? Does that make sense to anyone? So basically, this is no use anymore, right? Because it's been superseded by these legislative developments, which will in themselves lead to further climate change litigation at the Court of Justice anyway, right? Because these legally binding norms can be enforced by the courts. And the internal review in the amended Aarhus regulation can lead to further cases at the court as well. Yeah, yeah, maybe, but I still think, so I just still have this uneasy feeling that it is the court, not the court here, that has acted courageously. It is the legislator. Now, you may argue, but isn't that ultimately better in a democracy, right? Because now the democratic process has finally produced a more ambitious consensus. This was not under judicial pressure, so nobody can put, like on a tabloid, the judges as enemies of the people in this or something. You know, in populist times, it's much better if the democratic process produces such an outcome than if the judges have to impose it. Yeah, also true, but I still think it is very worrying that we have a court that in other areas, that was a bit too soon, sorry. In other areas of EU law, especially when it comes to economic interests and economic rights, has been extremely activist. When it comes to climate change, is nowhere to be seen and just waits for the political decision makers to find a solution and then to perhaps enforce that. I think that inequality of how, on the one hand, our court deals with economic liberalization interest, contrasted with this most important collective interest, is disappointing, not just from a green environmental point of view, but that has been my main case of concern from a constitutional democratic point of view. Okay, thank you for your attention.
Thank you very, very much, Sacha. It was all very, very clear and convincing. It tallied perfectly with the hypothesis that is behind the EUNMUTE project. Really perfect. And